Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we are a law firm that works solely on technology, cybersecurity, and legal issues. In each episode, we look at stories in the law related to digital technology from around the world and with an emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright, and we're just going to run through some of the news stories that have been coming up this week. I'll pass over to Peter to introduce himself, and then we will get started.
Hello everyone, my name is Peter. I'm a solicitor and the Managing Director at Digital Law, and looking forward to going through some of these stories with you, and also welcome to any of the people who hopefully are subscribing to this podcast or watching us on YouTube after the course that we delivered last week on ChatGPT and the law, when we had 550 people listening from all around the world, from jurisdictions as diverse as the United States and Canada, across Europe, through to places like Malaysia, Indonesia, Australia, all over the world. So it's great to have an international audience, and hopefully a few of you may have joined us here, in which case, welcome.
Thanks, Peter. So kicking off with a very interesting story that I personally found quite shocking. So as a little bit of context, I loved a bedtime story as a child. However, we are now talking about having an AI read a bedtime story. Very interesting. So teddy bears would be kitted out with generative AI, which could chat with the children and tell them personalized bedtime stories. And the worrying thing here is you can not only incorporate then the child's name, but their daily activities, who they go to school with, who their friends are, and it would be like a friend. But that's very worrying to me. It does give me very much kind of 1989 George Orwell. So I'll pass over to you, Peter.
Indeed, thanks, Amelia. I mean that is very 1984, isn't it? The scary thing there is the idea of the AI taking over the role of the parent, seemingly. I can understand the idea of using AI to generate a story about the child that you then read yourself to the child. That'd be quite a nice thing, a personalised bedtime story about something they may have done that day or a success they've had or something, make it into a story. Lovely. The idea here of entrusting the toy to do it, though, does raise some interesting issues from a security perspective. And some of our longer time listeners may be familiar with one of my favourite stories, the My Friend Kayla doll. This was a doll a few years ago that was being sold in shops across Europe. The idea being that this doll, which had a Bluetooth connection on it, the idea was that it could be connected to Bluetooth, and you could then basically talk to the child through the doll. The problem was that the Bluetooth connection was not secured, so anyone with a mobile device walking within about 40 feet of the doll could then connect to it through the Bluetooth connection and start talking to the child on the other end of it. And I don't think I probably need to go any more into the potential safeguarding issues around that and where it could go. So as a result, the Kayla doll, the only version of it now available in Europe is in the East Berlin East German Spying Museum, where it belongs. Now, what's that got to do with this? If we're now starting to get, obviously, IoT devices across the home, everything from your toaster to your kettle to your fridge to your toothbrush, all having smart enabled technology, it is also a matter of making sure that that technology is sufficiently robust and secure, so that particularly where you have lots of people living very close together in urban areas, it means that you are connecting your devices to your network and that they cannot then be compromised. Where you've then got, for example, this toy being sat with reading stories to the child, can you make sure that it can't be compromised? Could someone potentially hack into it and then start talking to the child or children who are hearing the story? And let's face it, if it is a large language model AI with a lot of generative power, what information does it need to have access to? More than likely, that would need a working internet connection. I think it's probably fairly safe to assume it might even have a 4 or 5G connection. enabled on it, so that it means that, of course, obviously, then if the child isn't at home, you can still have the generative AI. And now, 4 or 5G, that would be a secure link to a data network. But with the Wi-Fi, is that necessarily secure? Does it have the protections that we would normally expect? Is there an encryption key on it? So these would be the sorts of things that you'd want to know. And furthermore, that obviously you can have a password just to access something, but actually is the system it's operating on actually encrypted? Are there other security safeguards in place? And the final point, when it comes to a lot of smart technology, is that sometimes even the developers who have put the technology together are not aware of the amount of data that is being collected and where that data is then being sent. There is one UK university that carried out a study where it puts in a secure room lots of these IoT devices, let them then operate for a period of time, and then try to work out, well, where's all the data then being sent? And they worked out that about 80% of the time, the data was being collected that was more rich than the developers who had actually manufactured these items actually realized. And a lot of that data was then being squirreled back to other countries, more often than not China. But there was nothing on the packaging, nothing on the systems, nothing in the instruction manuals or the online guidance that said to the user, your data is being sent to China. So you're buying something without necessarily knowing what data it's collecting and where it's being sent. The same thing will apply to this toy. And I think, Emily, did you say it was VTech?
Yes. So it was looking at VTech, which is in fact a Chinese-based company that are looking to kind of start with this generative AI teddy bear. And I think another point worth mentioning here is we have got more and more staff working from home. So if you've got children working from home, there are chances are these toys could just be left anywhere. So if you are then taking a business meeting and you've got this AI teddy bear gathering who knows how much data, that could really impact someone's business. I mean, we were on, like you say, we did the ChatGPT webinar last week. Someone accidentally turned their microphone on and almost revealed some very confidential information. And it's as simple as that. If you're in just a standard meeting and you've got this teddy bear or piece of technology there is every chance it could pick up things that you don't necessarily want it to know.
Yes, that was an interesting moment when you've got over 500 people on the line, and then someone clearly flicked on the sound, and you could tell that they were talking to someone else in the office and were about to start discussing work. And it was during the break, so I ended up sort of unmuting and going, whoever's got your mic on, we can hear you. Please stop talking. We don't want to hear as you breach client confidential information. And they realized who it were, that we were referring to them, and muted themselves quickly. But that is the point. When you have a speaker that is always on, what's it going to pick up? We've had this problem with everything from smart speakers that are always on, collecting information. If you are working from home, you might not realize that you have a Apple or Amazon device sat there that is always on and listening. Google, of course, have one as well. It could be sat in the corner. And then the same thing then goes for a lot of these IoT devices that might have an open audio channel. Even if you think, well, why would you have an open audio channel on a toaster? These things happen. Even with with these vacuum cleaners that the robot vacuum cleaner that you have going around, hasn't got a speaker or mic on it or anything, but the sound, because it scans sound waves so it doesn't crash into your furniture, that the data from that can then be reconfigured so that you can actually then hear what's happening if that device is hacked, and you're a hacker who knows what they're doing. And increasingly there's freely available info on the dark web that allows you to go ahead and do that. So the point is that if you are working from home, it's actually worth thinking, well, you could be in a study, you close the door, the family's outside the door, and you can then work away knowing that you're not being listened to. If you're sat in the lounge or in your kitchen and you have a load of IoT devices in there, think very carefully about what else is in there and what else could be potentially listening, particularly if you are working in a highly regulated sector like law, accounting, medicine, financial services. You get the point. The offices that as a highly regulated professional you work in have been specifically configured. The tools that you're working with are configured to, or they should be configured, to demonstrate compliance with regulatory objectives around privacy, security, client confidentiality, etc. If you're at home, then that could be quite easily breached. So this is just another example of where we've got the merging of the workplace and home, where you're then potentially working from home. These are the sorts of things that we really do need to consider.
Thanks, Peter. So moving on to our next story. So this is looking at the Information Commissioner's Office. They have issued a reprimand to Thames Valley Police. This is after details were released which led to suspected criminals learning the address of a witness. It's alleged that the police did not take appropriate steps, such as training, to ensure that officers were aware of guidance around disclosure and redaction. And this is obviously then a breach of not only data protection law, but definitely a breach of confidence in the police as well.
It is. I think we should have a regular feature now, which is sort of law enforcement breach of the week. Because I think we had the Ministry of Justice the other week. I think we've had Magistrates Court Service as well at different times. And now we have Thames Valley Police. I mean, we've had the ICO has done significant pieces of enforcement against the police and some of the contractors that they use. Because quite often information related to people's criminal records and offences ends up going and being shared in ways that it shouldn't be. I think the thing that is worrying about this one is that, on the face of it, yes, it's a data protection breach, and that's why the ICO is involved. But it's a bit like, and we were just talking in the previous story about those professional duties of things like confidentiality. And, when you're a doctor, one of the first things that they drill into you is the importance of patient confidentiality, and the stuff the patient tells you doesn't go any further, or it's recorded very, very carefully. You don't go and then broadcast information about someone's illness. Very often you won't even tell family members unless the patient's happy with that. Similar thing as a lawyer, client confidentiality. Now, you'd think with the police that information about current and ongoing investigations would be confidential, and that in particular information about the witnesses that you're speaking to would be confidential, and it certainly then wouldn't be shared with the people that are being investigated themselves.
It does bring up some quite key questions there. That how on earth does this happen?
And they've said, they're going to improve training, and you're like, well, it's a pretty fundamental bit of training there, isn't it? That seems to have been overlooked. I'd have thought that was, when you now join the police in the UK, you actually have to get a policing degree. That is, you then basically study intensively while you're on the job, and you get this policing degree, which when I've spoken to them people in the police, I've said they aren't necessarily fans of it, because they're like, well, it's not transferable. You work, you do all this, and then it doesn't give you a skill or qualifications that you can take away with you. It's only useful or recognised within the police. But the point is that you've done a lot of work and study. Now, talking about those other professions that we just talked about, I say one of the first things when you walk into your first lecture, your first seminar, is the importance of this stuff, and it is hammered home to you in a fairly, or certainly to me 20 years ago, it was certainly rammed home in a fairly direct way, to the point that I'm really funny now. Sometimes we've got clients who are like, oh, we've loved the work that you've done, and please do talk about it. I'm like, well, unless I have it sort of written in triplicate in blood that you're happy for that, we're not talking about it. And we aren't going to use it for marketing. We're not, unless we know you're happy with it and we've got it explicitly clear. And as a general rule, we don't do it, because it's not something, I don't want to put my clients in that situation of, are you happy with us doing this or not? The whole point they come to us very often is because they want that privacy of knowing that we can discuss this, and we're not going to then plaster it all over marketing material. So it's a really fundamental point. And then in this instance, where you've got people saying, okay, well, I will actually provide witness evidence about a offence that I have witnessed. You want to make sure that those people feel that they can trust the law enforcement agency they're giving that information to. That it's not going to be just sprayed out far and wide, which appears to have happened in this instance.
Well, exactly. And it's like you say, Peter, it was hammered home to you about confidentiality when you were training, and I'm an apprentice solicitor myself, and it is one of the key things that we have to just be able to demonstrate throughout our training, because we literally have to prove how we are helping to keep client confidentiality, which, as you say, we try not to have that waived. And realistically, we do have to jump through lots of hoops. Like, we need this in writing, we need it on file. And the fact that, I mean, I feel like a primary school student would know that you don't tell the criminal where the witness is, you know?
Evidently not.
Yeah, well. Moving then on to look at a different sort of crime. So this is looking at a hacker group called Clop. So they have been posting names of firms to its website on the darknet, where they've got company profiles of victims and basically a mass hack. And they've just gradually been publishing different pieces of information. And so far, 26 organizations, including banks and universities, have been added to the darknet site to try and pressure victims into paying. There have also been US federal bodies that have been targeted, as well as the oil giant Shell. So very interesting that they've hit a lot of kind of big players here, and a lot of attacks specifically looking at critical infrastructure. So yeah, Peter, what are your thoughts here?
Well, I think the story here actually isn't so much, large number of organisations hacked. This is a regular story. In this, I think it's the range of those organisations, both across public and private sectors in multiple different countries. But I think it's interesting to contrast that, given, I think, a lot of the organisations that are out there that very often say, "Oh, we're fine in terms of cybersecurity. We follow industry best practice, Oh yeah, the IT team are following that. Oh, we use Microsoft, we do this, we do that. I'm not saying that Microsoft was in any way involved in any of these. I'm just saying that very often you tend to think, oh, because we're using, well-recognized products and services, that we're doing what everyone else does, therefore we must be safe. Well, guess what? These massive corporations, these governments will have significant resources that they'll have paid to have in place here. They'll be using a lot of the sort of recognized products and services that everyone else is used to using. And guess what? If you're using a widely recognized product or service, that means the hackers are putting more resources at being able to get into them. And that's what's happened here.
I mean, especially when you're looking at kind of the US federal bodies that have been targeted. Realistically speaking, they're going to have more funding than your average Joe Blogs company. Or you'd like to think, certainly, to be able to buy that infrastructure and the cybersecurity to ensure that these attacks are not going to be happening, because they are going to be processing personal data, which is rich and sensitive. And I mean, it's federal government. You know.
And there'll also be the usual issues, which has probably led to this as well, around legacy systems. So the bigger the bureaucracy, the more likely is that either they've got old systems that they are probably supporting, either the developer has long since gone out of business, or the developer is working with them directly to try and keep it going while they search around vainly for something that can pick up the functions that it has. I mean, the amount of running repairs that a lot of IT teams spend their time doing with old legacy systems on legacy hardware, legacy systems that the procurement decisions for which were taken decades ago, and that they're still trying to use, as I say, very often at a great cost in terms of not just money, but also staff time on keeping things going. You'd be surprised how often that happens. Sometimes, particularly with government at a federal and state level, they simply then haven't got the budget to be able to go out and get the new systems that they actually need, and that remains an ongoing problem. I think the other key thing here is look behind the headline, which, okay, these organizations have been hacked. How do we know that? Well, it's because the information has then been started to be published on the dark web. So the hackers have said, we are going to start publishing data on the dark web to actually then potentially make you pay ransoms or comply with whatever it is that they're trying to blackmail the organizations that have been hacked into doing. So two things we need to think about there. One is that a cyber attack is not just a single incident. always think about the kill chain. What's the kill chain? This is something developed by Raytheon, which shows, I think it's Raytheon. Anyway, but basically it shows sort of 8 definitive stages that have been sort of discerned as being key parts of a cyber attack. Everything from the reconnaissance that's carried out, to then the hackers working out how they're going to hit an organization, carrying out that hit, then potentially sitting on a network for days, weeks, months, even years, while they then look to see how best to exploit it, take it down, get the information that they want, potentially get the information they need so that they can hold someone to ransom, and then sometimes even getting as far as full command and control of a network and achieving all the objectives that they'd originally set out. So I'd be interested to know, well, what is most likely happening here is a lot of these organizations are probably still continuing to investigate to see how heavily they've been hacked, whereabouts they are on that kill chain, trying to make sure the hackers don't have any more access, seeing what sort of damage has been carried out and what damage could yet be carried out. But then the other key thing here is that we've also got information here from companies in the US and US government. Bear in mind that in the US, it's a very different environment from in Europe. In Europe, you've got to report any serious breach within 72 hours of the breach being identified and date of knowledge. Yet in the US, the advice is basically don't tell anyone it's happened. You don't have to, so shut up about it. You'll only frighten the horses, sort of thing. And usually corporations will only go public on this if they are publicly traded. And at that point, there are rules from the Securities and Exchange Commission that mean that you then have to go public, because you then have to notify your investors, because a serious breach will have serious liabilities and you have to tell those investors of those liabilities. So there's that point there. In this instance, the only reason, therefore, we know this has happened is because the hackers are leaking the information on the dark web, saying we have hacked these organizations and here is the data that proves it. So sometimes it's actually a bit of an indicator. You think, well, particularly in some jurisdictions like the US, where there isn't the duty to report, you can probably take the number of confirmed hacks and incidents that we see like this and probably double it, add a 0 on the end to get a figure of the actual true number of sorts of hacks and breaches that are taking place, because there simply isn't the reporting background history and infrastructure that there is from a regulatory perspective in other countries.
Thanks, Peter. So moving on to kind of looking at other countries now. So we will be looking at the cryptocurrency boss behind the Terra USD stablecoin. So this essentially, the Terra USD stablecoin collapsed, as well as the associated Luna tokens. And this kind of rocked the cryptocurrency markets about this time last year. And so Do Kwon, who was the boss behind the project, he has been sentenced to 4 months in jail in Montenegro. And interestingly enough, this was due to being found that he had forged official documents, not in a sense of the massive kind of fraudulent cryptocurrency side of things. But interestingly enough, he is facing charges from other countries around the world, but Montenegro does not have an extradition policy to the US and Korea, where he is also wanted. So it's kind of half a positive there. You know, we have got this guy facing up to some of his crimes.
And potentially then being investigated for more. But interestingly, the only thing that's stuck so far is forging official documents and 4 months of jail time.
How very Al Capone.
Very. The interesting thing with this, though, is it illustrates the contrast that we currently have between the sort of world of regulated financial products and services, where certainly when I talk to people who work in the financial services sector, and particularly in the UK, where we've got the Financial Conduct Authority and the Bank of England and Prudential Regulation Authority, all of this means that overall it is a very heavily regulated sector, financial services, to the point now that sometimes what would be deemed as an average investor in many countries is turned away by a lot of financial advisors in the UK, because they say, look, you might be wanting to invest £20,000-30,000, but such are the regulatory burdens, it's actually not worth us even trying to advise you unless you've got 6 figures to invest. Very sorry. So then what's that person going to do? They'll think, well, I can't put this into a normal security investment structure, trust, whatever in the UK. Put it into cryptocurrency though, which is, for the most part, pretty much entirely unregulated. There is a register in the UK for cryptocurrencies based in the UK. It should be on that register. Over and above being on that register, in terms of how effective the Bank of England is in its oversight, I think the jury's probably still out on that, but you can take a wild guess. And the point is that where you've got very heavy regulation on the sort of the official part of the financial services sector, you then come to the wild west of cryptocurrency, and it seems that anything goes. Even though everyone's probably seen the headlines about where cryptocurrency, you've had obviously FTX collapsed, and then a lot of money was lost in the cryptocurrency market over the course of the last 12 months. It's starting to come back in many jurisdictions. People are putting their money into it, and when you look at the heavy regulatory oversight in many areas, you can kind of see why. So in this instance, even though we have the Terra USD stablecoin having collapsed, along with the associated Luna stablecoin, there are still huge numbers of cryptocurrencies and assets out there that continue to benefit from a lot of investors. Very often it is the smaller investors rather than the big institutional investors that are the ones that are putting their money into it and can be at risk. While it's good that this individual has been found guilty and is serving some jail time, he's still not facing any charges at the moment in relation to the actual or serving time for any successful charges that have stuck in relation to what happened to that currency and stablecoin. So the whole point is that those investigations remain ongoing. Let's not forget as well, of course, FTX, that continues to roll in the background. Sam Bankman-Fried, a load of the charges against him actually were dropped recently. So while others were added. So, that continues to roll. And I think while they try and work out what on earth was happening with an FTX, that's going to take months, if not years, until we actually get any resolution. But in the meantime, I think this story illustrates the fact that it is still very difficult to regulate the cryptocurrency sector. And that also then potentially having anyone face any justice in relation to anything that may or may not happen in there remains very, very difficult due to the various jurisdictions that we're looking at, the complications of trying to do things from a multi-jurisdictional perspective. It means that very often individuals like Mr. Kwan would remain out of reach.
Thanks, Peter. Moving back towards the UK now. So 2 EU countries have accused the Transport for London's Debt Collection Agency of breaching data protection laws to obtain names and addresses of citizens in order to issue fines for driving in the capital. So this is very interesting, Peter, because you were explaining this to me earlier. So I will pass this on to you. And why, on the surface, this doesn't seem problematic, but actually digging deeper, you can see that there are not quite the right rules and regulations in place here.
Indeed. So this relates to London's ultra-low emission zone, the ULEZ, as it were. This has been in place for a little while now. We also have a congestion charge zone. It's actually been in place in London now for the best part of 20 years. The whole point is that if you happen to drive your vehicle into the centre of London, for those who've been to London, think about that zone 1 in the centre, on your tube map. This roughly equates to sort of driving into that area, but the ultra low emission zone, they're looking to expand it more into suburban London, and indeed the congestion charge, they did look at expanding that further, but then that was suspended eventually. But the whole point is that you have these zones within the centre. Other cities in Britain are looking at doing this. So we have a emissions zone in Sheffield, ultra emissions, and they were going to introduce one in Manchester, but that's been suspended. But
They introduced one in Bristol as well, and Birmingham.
Yes, and they're seen as one way of trying to actually reduce some of the congestion in city centres by saying, look, you are going to pay more if you're going to bring in these high emission vehicles into the city. Obviously, where you have vast amounts of congestion and loads of vehicles sat there on tick over, it's not great for the environment, not great for the people that live there either. So that's the aim of these things. In this instance, London being the international city that it is, you get a lot of people going to it who are tourists or going there on business. And in this instance, a number of very large fines have been issued against those who've been driving over a period of time in the city centre, very often foreign motorists. And actually, part of this story relates to the fact that even though they had pre-registered their vehicles and thought that they were safe to enter and had then paid the charges, they're then somewhat upset to then get these penalty charge notices that come through. They can end up totaling thousands of pounds, because what starts off as being a daily charge, if you don't pay it on the day, it starts to increase. And the longer that you don't pay it, the more it starts to increase. Then they throw some interest on the side as well. So before you know it, you're looking at a really expensive fine or fines. And the point here is that then the contractors used by the ultra-low emission zone, you've got personal data of EU citizens being processed by the ultra-low emission zone, then potentially being sent for enforcement by a third-party company. The fact that I believe there were issues around whether the data that was being shared, they didn't necessarily have a data transfer agreement with the correct standard contractual clauses in place, which are mandated now. There may have been some misunderstanding with regards to how the UK's adequacy arrangement with the European Union works as well, and the fact you've got data of EU citizens being processed. But nonetheless, even if you have an adequacy arrangement in place, you still need to have adequate data sharing between mechanisms in place between the third parties, in particular where that processing might be taking place then in a third country that a third party might be using to undertake their data processing activities. Very, very complex, but it illustrates how when it comes to the operation of these big bits of bureaucracy now, more often than not, efforts will be made to try and minimize those costs, and it could mean then that data is being sent all over the world in order to what might seem a fairly straightforward registration and enforcement exercise could mean data is being processed in multiple different jurisdictions, affecting tens of thousands, maybe even hundreds of thousands of data subjects in this instance. So, these schemes we're going to be getting more of them in more cities across the West. And I think the question there is, are we going to have confidence in, as these things are being set up, are they going to be processing vast amounts of data, everything from registration numbers and then the information behind that gives details of people's names, addresses, potentially, this is information about, is the vehicle taxed?
You've also got then potentially medical information if you're looking at licensing, and you have to declare certain, like if you're epileptic, you have to be able to declare that on your license.
Yeah. Do they have a disability badge so they can make use of the parking? All of these things are likely, that sort of information is then likely to be sort of processed back and forth. And you'd want to make sure that is being done in a safe and secure manner. Because if it then isn't complying from a regulatory perspective, which is the point of this story, does that then lead to it potentially being vulnerable to being hacked, which was our previous story was about, neither of which is good.
Thanks, Peter. So moving then on to our final story of the day. So we are looking at the tech giant Spotify. So Spotify is facing a fine of around 5 million euros in Sweden, years after it was accused of breaching the data access rights of users in the European Union by not providing full information about personal data it processes in response to individual requests. So we talk a fair bit about subject access requests, and I believe we've covered stories in the past where companies are not fulfilling them in the correct amount of time. But here, it's interesting that these responses are not quite cracking up to what they should be. So I'll pass it to Peter to take us through the regulation here.
Thanks, Amelia. I mean, there's a couple of interesting takeaways on this. One is that this all stems from the straightforward subject access request, which I think sometimes organizations take for granted. And in this instance, Max Schrems, who leads the NOYB, None of Your Business, not-for-profit, has made a number of subject access requests to multiple different organizations and is then querying how they have responded and potentially then complaining to the regulator about how those organizations have responded. In this instance, he's complained to the Swedish regulator, which is the lead data protection regulator in Europe for Spotify. to say, look, the manner that you have responded to this subject access request is not correct. I mean, a lot of people get confused with SARs and think, oh, you reply to this just by providing copies of all the records of personal data that you hold about someone within an organisation, and it isn't. It can be that, but it doesn't necessarily mean that you have to sort of, for example, release thousands of redacted copies of emails and call scripts or call recordings. That's not what the legislation is about. It's also about telling people how much personal data is collected, why it is collected, who it's shared with. Those are all the sorts of key bits of information that you need to be disclosing when you respond to an SAR. Now, in this instance, it looks like the complaint is that Spotify didn't respond with all of the information that is required under GDPR to the subject access request. But also it seems that Spotify was using an automated tool to respond to the SAR. And it seems that that automation was producing an output that did not comply with what the law actually required. It complied with what someone thought an SAR requires, not what the law actually does, or going from a practical perspective, making sure that the individual got in a readable and understandable format a clear response to that subject access request that said, here are examples of the data that we've got, this is what we're using it for, this is why, etc., etc. So the outcome of this is that we've got a significant fine. It sounds a lot more impressive when you say, I think it's 58 million Swedish krona is the value of the fine, which is then 5 million euro. But it kind of shows how important it is to ensure that something that can seem as straightforward as a subject access request is responded to properly, otherwise you can get significant regulatory enforcement. And also the fact that automated tools, which they will have purchased and paid money for this thing and added it to their site and relied on it, just because someone's produced a product or service that claims to comply with a regulatory requirement does not mean it does so. This is something I constantly run up against. The number of conferences and events I go to where there's vendors saying, oh, well, we've got something that does this and we've done something that does that. And when I look at it, it doesn't. And then you raise this question, and the people in the suits and with the handshakes and the smiles can't answer the questions you're asking because they don't know. They've just been given a load of sales spiel, and you don't get anywhere. But just because someone's selling something, as I say, that says with a nice shiny front of the box, oh, it does this. Does it actually do that? That's what, unfortunately, some of these very large, indeed some of the largest tech firms in the world, are finding that just because they've added something to their service that they think demonstrates regulatory compliance with the requirements of GDPR doesn't mean it does so.
Thanks, Peter. So that was our last discussion for this episode. But if you'd like to hear more from us, including subscribing to our newsletter, as well as receiving information about subscriber-only podcasts and webinars, then please subscribe to our premium via our Patreon channel using the link in the show notes. A big thank you again to Anson Evaluate for helping to produce this webinar. And if you'd like to produce your own podcast or webinar, or you're interested in hearing more about Anson Evaluate's services, please look at their website that you can find at www.ansonevaluate.com. These episodes are available on our website, YouTube channel, podcast channels as well, such as Spotify, Apple Music, Amazon Music, and Google Podcasts. And please feel free to leave us a review. And finally, if you have any questions about what we've talked about today, please feel free to email us at admin@digitallawuk.com. Thank you for listening, and we hope to see you again next week. Thank you.